Second argument set to be heard today is 24-1785, State versus Moothart. Appearing on behalf of the appellant is attorney Trevor Jordison, and on behalf of the appellee is Samantha Stewart from Drake Law School. So, counsel, when you're ready to proceed.
Please the court. Counsel. This appeal turns on one of the most fundamental guarantees of the criminal justice system, the opportunity for a defendant to confront, challenge, and scrutinize the evidence used to justify conviction. In this case, the state, after choosing to proceed with a Chapter 808 search warrant instead of going through the implied consent framework, destroyed the only physical evidence in this case, the blood specimen, without defense input, without judicial permission, and in violation of the court's discovery order. That destruction, after explicit discovery requests and direct discovery order, denied Mr. Moothart the due process and a fair trial. In this case, the state withheld and destroyed materially exculpatory evidence the morning of the first day of trial. 48 minutes before trial was set to begin, the state, for the first time, introduces a chain of custody document that had never been disclosed to the defendant. And that chain of custody document had two important points. One, it is the first time the defendant is notified that the blood test at issue had been destroyed. And two, shows that there's about a 5-day gap between the time the test was taken and when that chain of custody document begins.
Though that was the first time your client got notice that it was destroyed, even before getting that notice, your client knew he didn't have, he did not have the blood, he hadn't had it tested. So how's that harmful to him in any way?
The state's DCI witness, this is, I believe, on page 33 of day 2 of the transcript, specifically testified that when you've got breaks in the chain of custody, that undermines the accuracy of the blood test. It can, it calls into question the test itself. And so while Mr. Moothart knew that he didn't have the blood test, he didn't have it independently analyzed, it wasn't until the morning of the first day of trial that that he was aware of this gap in the chain of custody, because that had never been disclosed to the defendant. And the state knew about this gap in the chain of custody as early as June 13th in 2023. So a year and 4 months prior to trial, the state was aware that there was this gap in the chain of custody. I know at the transcript at the hearing, or at the new trial hearing, the prosecutor stated that she didn't know this existed. But that specifically, the chain of custody document specifically relates to the evidence in this case. It is subject to the motion for discovery and subject to the court's September 11th, 2023 discovery order. And the fact that the prosecutor didn't do the investigation necessary to adequately produce the discovery that she was required to is not a basis for to then destroy the evidence and have the defendant be prejudiced by it. And under the 808 warrants, there is a specific requirement that that this evidence be preserved until after trial. That is Iowa Code 808.9, which states that it has to be safely kept so long as reasonably necessary to enable its production at trial and subject to the court having jurisdiction to try the case. That is a code provision that doesn't appear in the implied consent framework. And so you've got a number of cases talking about destruction of blood evidence in the implied consent arena. However, the only case that is discussing the destruction of evidence outside of the implied consent in Iowa is the Delaney case, which is a 321J case, where the defendant brought up that this evidence, the blood sample was destroyed, and tried to use 808.9 as the basis for objecting to that destruction.
I think the statutory argument is an interesting one, but from my review of the record, it looks like in the district court, the statute wasn't, there wasn't a statutory violation argument made. There was an argument that it, was hearsay, that it was a best evidence violation, and that it was a due process violation. So aren't we limited to considering whether it's a due process violation here now?
No, Your Honor. I believe in the hearing on the motion for new trial and arrest of judgment, that statutory argument was preserved and was argued to the district court.
I think, but it looked to me like it was primarily as a subset of a constitutional due process argument, and which is, I think, how I read your brief on appeal here too, focusing on it being a due process violation. And my main question on that claim is I think there's quite a bit of both federal and state precedent that in order to succeed on a due process claim, you have to show it was potentially exculpatory. And how do you meet that standard here?
Yes, Your Honor. And that under the Delaney case, they go through a lot of that due process analysis. And in Delaney, it is, they go through the materially exculpatory or, is it destroyed in bad faith? And I think that both are present here. When you've got the state knowing that there is this break in the chain of custody, failing to turn that document over until 48 minutes before the first day of trial, and at the same time destroying the underlying evidence in violation of very clear statutory protections in favor of the defendant, that amounts to bad faith. Additionally, whether this is materially exculpatory is, there's testimony from their own witnesses about saying, when you've got these breaks in the chain of custody, it calls into question the validity of the test, it calls into question the accuracy, all of these things, which Mr. Moothart was completely deprived of any opportunity to rebut that. And, had the state not destroyed the underlying evidence, if you get a late piece, you get the chain of custody on the first day of trial, there are potential remedies going forward that can lessen the prejudice. You could ask for a continuance and have the test, the specimen tested, but none of that is present here because of the illegal destruction of the tested issue. And so,
The record that the lab destroyed the sample other than pursuant to its usual practice.
my understanding is that generally these are 90-day, tests are destroyed 90 days after the DCI receives them. In this case, we're looking at, I think, 7 or 8 months after the DCI got the test that they then destroyed it. Additionally, under, so 808.9, Iowa Code 808.9, specifically points you to Iowa Code Chapter 809 for how you should dispose of these evidence. And I know the Appellee in their brief says, well, they got notice that we had this test, but nowhere in the attachment to this is to docket 4, the first attachment nor the second attachment does it say that the state is going to destruct this or destroy this evidence. It gives notice that they have the evidence pursuant to to Iowa Code 809, but it doesn't say that this is subject to destruction in 90 days, nothing like that. And so the defendant is entitled to rely on the statute that says that they're going to retain and keep safe this blood sample and rely on the state to meet their obligations under law. And so when you've got the late discovery of the late notice that shows that there are issues that the defendant needs to investigate, and it's 48 minutes before trial, there is no adequate opportunity to confront that evidence, and that is a due process violation. And I'm out of time. Thank you.
Time on rebuttal. Ready.
May it please the court, counsel. Your Honors, I'd like to start off by addressing the chain of custody issue, as this is an issue that has not been preserved for appeal today. Now, to preserve error on the grounds of chain of custody, a timely objection must be made at trial that specifically identifies the manner in which the chain of custody is deficient. Now, opposing counsel never had the opportunity to make such an objection here because the actual chain of custody document itself was never admitted at trial. Further, the only evidence of a break in the chain that's been pointed to was the time before it was in the custody of the DCI, when it was with the Waukee Police Department. And it's true that there is a 5-day gap there before the chain of custody document starts, but there is a permissible presumption that law enforcement and state agents did not tamper with evidence while it was in their custody. There's no evidence in the record to suggest that bad faith occurred during this time or that the evidence was tampered with in any way. Then when the blood sample came into possession of the DCI, the same chain of custody requirements were no longer needed at that point. So the time for Moothart to have resolved any ambiguity surrounding this chain of custody document was at trial and not here today on appeal. During trial, he had the opportunity to cross-examine the witnesses who testified about the custody of the document, both at the DCI and beforehand. The only question asked was whether a break in the chain would cause a question about the reliability of the test results, to which the witness responded that it would. But, Your Honors, this was not a sufficient timely objection that specifically identified how the document was deficient, so this chain of custody issue has not been sufficiently preserved for error. Now, as to the issue of the disposal of the blood sample, last year in State v. Laub, the Iowa Supreme Court clarified that 2 different paths can be taken: 321J for an informed consent warrant, or Iowa Code Chapter 808, which was used here. And this is just a standard warrant. Now, under Iowa Code Chapter 808, disposal must be in accordance with Chapter 809, and as already stated, property of an evidentiary nature must be kept so long as reasonably necessary to enable production at trial. Now, the actual physical blood sample here is not the type of property of an evidentiary nature that requires this retention in the first place. It may have had some evidentiary value to it prior to being tested. However, once that blood sample became tested, its evidentiary value and content became embodied in the test and the interpretation of that test result instead of the physical sample itself.
Counsel, I'm not sure I understand that argument. And I don't know that it's fatal to your case necessarily, but since we're going there, why wouldn't it be of an evidentiary nature if it then would have still been possible for an independent test to be done of the blood? If there was some belief from the defendant that there was a break in the chain of custody and something was wrong, here, and wanted to verify that.
That question as to the test results and the opportunity for an independent test, it may be different. However, under the circumstances we have here, that actual blood sample itself, after being tested, didn't tend to prove or disprove whether he was intoxicated while driving a motor vehicle. Instead, that all comes from the actual test result document itself. But even so, the state did comply with Chapter 809 in its disposal of the blood sample. 809 has a notice requirement and then gives defendants the opportunity to seek the return of their seized property. If they don't seek for return under the processes outlined in Chapter 809, it's then disposed of according to standard procedure. Now, here Moothart was twice over given notice, both by the DCI test lab results, and then before that, in the first attachment to docket number 4, there's a Waukee Police Department inventory from when the blood sample was taken. And nowhere in the record does it indicate that after being given these notices, Moothart applied for return of the blood sample or preservation of it through the processes outlined in Chapter 809. Now, under these circumstances, it can be presumed that the DCI followed its standard protocol. It tested the blood sample and then it disposed of it within 90 days afterwards. Further, to be entitled to any remedy at all for the destruction of this evidence had it been improper, it must be shown that the evidence had some apparent exculpatory value prior to being tested or prior to being destroyed, and that it was intentionally destroyed in bad faith. But neither of these prongs can be met today. First, it's unlikely that the untested blood sample would have any exculpatory value. The tested sample showed that he was over 2 times the legal limit for his blood alcohol content, and the mere fact that a different test may have shown a slightly more favorable result is not enough here. He has to be able to show that the untested blood sample would have produced favorable evidence, and that is just simply not the case here. Similarly, this was not intentional in the sense of bad faith. The DCI was following its standard protocol of test and dispose in 90 days. Under these circumstances where Moothart was given notice of the DCI's possession of the blood sample and he did not apply for the return or preservation of that sample, it was not an abuse of discretion for the district court to then allow testimony about the testing of that blood sample. Similarly, this was not intentional in the sense that it violated the discovery order. Moothart filed a motion for discovery, and then the court filed an order to produce that required the state to comply with Iowa Rule of Criminal Procedure 2.14. Now, notably, that motion and the order and the rule, none of them required the state to produce that physical blood sample. Now, once the state complied with this within 14 days, there was no further request for the physical blood sample after it hadn't been turned over. And this is despite the fact that Moothart was aware that the DCI was in possession. Even before having filed that motion for discovery, the test results had been completed weeks prior to that. Again, under these circumstances, this can't be said to have been an intentional violation of a discovery order in the sense that it violates due process. The DCI wasn't aware that anyone wanted this physical sample to be retained, and it just followed standard protocol. In State v. Delaney, the court held that following standard protocol does not rise to the level of a due process violation, absent that exculpatory and intentional factor. It's for similar reasons that the testimony regarding both the chain of custody document and the test results was not an abuse of discretion or a violation of due process for the court to have allowed. Now, Moothart had the opportunity to cross-examine both of these witnesses about both of these topics. As I stated earlier, there was only one question asked about the chain of custody, and there were some questions asked about the testing, but the actual test results and the actual chain of custody document itself were not offered into trial. Under these circumstances where neither was offered into evidence, Moothart had the opportunity to cross-examine both witnesses to question the reliability of those test results. The evidence shows that this was not an abuse of discretion, and it does not rise to the level of an abuse or a due process violation.
Chain of custody issue with the blood sample, the appellant also raises a substantial evidence claim regarding the other evidence produced. Could you speak to that, particularly the body cam video that was admitted?
Yes, Your Honor. So the sufficiency of the evidence here is more than met. From the body camera footage, we have several things that we can see. Not only that the witness or the defendant himself was next to the road alone next to a tipped over bicycle, we found out he was the registered owner, and in the video we can see some of the same signs of impairment that the officers testified to at trial. We saw signs of bloodshot eyes, a smell of alcohol that at least one of the officers observed. He had impaired balance that can be seen in the video, and his speech was slurred. These are all more than sufficient evidence of circumstantial evidence to show that he was operating a vehicle while intoxicated. Now, there's questions about whether he actually was riding the motorcycle because no one saw the crash occur. However, he was the only person on the road. He said he was going from a buddy's house to Winterset, which was several miles away from the crash location. And based on this evidence, it was available and it was capable for a jury to find that he was operating a vehicle while intoxicated. So, Your Honors, in sum, the chain of custody evidence or issue has not been preserved for trial today or for appeal today. The state complied with procedures in 809, and the disposal of the blood sample does not rise to the level of a due process violation, and the evidence is more than sufficient to support the convictions. So for these reasons, the state respectfully requests that this court affirm the decision of the district court. Thank you.
Counsel Rebuttal, when you're ready. And if you would start with that substantial or sufficiency of the evidence challenge outside of the chain of custody for the blood sample.
Thank you, Your Honor. May it please the court. The sufficiency of the evidence argument is based on the fact that nobody saw Mr. Moothart operating the motorcycle. Nobody knows what time he was operating the motorcycle. Nobody, I mean, the entirety of the evidence presented at trial is the Waukee Police Department comes up and sees a man standing on the side of the road next to a motorcycle. And so, especially without the evidence from the blood sample, there's just simply there is no sufficiency of evidence to justify a conviction. Even with the blood sample, it is still not enough. But as counsel was arguing, tampering is not the only issue related to the chain of custody and blood sample. I mean, when you've got a 5-day gap in the chain of custody, nobody knows or testified where that test was. Was it refrigerated? No, I mean, these are all questions that we just don't have answers to, and compound the prejudice of getting this late chain of custody only to find out that the test is also destroyed. Additionally, under the normal procedures, I believe counsel was arguing that this is routine procedures, shouldn't be an issue. First, routine procedures that violate Iowa law cannot be upheld by this court. I mean, the law is clear that when you have an 808 warrant, the evidence seized needs to be preserved until trial and put it under the judicial oversight of the trial court. And at no time did the state ask the court, make a motion to the court asking for permission to destroy this sample. And the routine destruction of this evidence is in direct violation of Iowa Code 808.9 and can't be upheld. I do want to touch on the hearsay argument that was raised in our brief, but before I do, I do want to mention on the chain of custody issue, that was argued at length in the district court. Although the prosecutor chose not to because of the late disclosure of this chain of custody document, she chose not to produce it or make it an exhibit at trial. But that doesn't defeat the issues related to the destruction of the blood test and the chain of custody, which are so intertwined that they can't be separated out as one or the other because they rely so heavily on each other. But the hearsay part of our brief is relevant here as well because the prosecutor did not make the blood test results an exhibit at this in this case, nor did she make the chain of custody document an exhibit. The only evidence of intoxication that was allowed at trial was the testimony of the DCI lab technician who gets a report from the testing machine, reads it, and then came into court and relayed what the test results from that piece of paper were to the jury. And
is there a hearsay argument? I saw it listed on the statement of issues presented for review, but then in the argument section, I didn't catch where there was any argument making what you just said.
Sorry, Your Honor, let me pull that up. I, it is not in the appellate brief. I apologize for that.
Thank you. And I do see you're out of time, Counsel. Consider case 24-1785 fully submitted and will issue an opinion as soon as possible. With that, we will be in recess until 9 a.m. tomorrow.